company.
The performance of the company, with your first quarter numbers, the group CEO says that the good performance, of course you posted almost 2 billion naira. Your revenue was up more than 100%, 116, almost 120%. The CEO says that was made possible, quote, by the successful restructuring of the company in 2016. Explain to us what some of this restructuring you did and what's been the outcome of them.
Okay, some of the challenges that the company had prior to 2016 was things like the level of leverage that we had as a company.
That's indebted.
Yeah, the indebtedness that the company had. We had some assets that we didn't think were necessarily a strategic fit with the future of the company. And those things, more or less, were some of the things that were weighing down the company's performance. A decision was made to let go of some of those assets. So, for example, last year we let go of the energy services company. The energy services company is the company that services all companies in the oil fields. We decided that the capital requirement was not something that we would be able to meet, and so it was best to let it go. We disposed of a fairly substantial part of our ownership of the downstream company. That's the gas owning stations. At that point in time, we disposed of about 60% of our ownership of the company. And towards the end of last year as well, we disposed of about 70% of our ownership of the gas pipeline business, Oando Gas and Power. The effect of all those things is we were able to generate quite a bit of capital. The capital that we generated enabled us to pay down quite significantly the amount of debt that we owed the banking industry. So in 2015, we owed in dollar terms, about $2 billion. Today, our indebtedness is just north of $700 million. And the reduction in the debt was driven mainly by the proceeds of the disposals we made.
One of the allegations by the SEC was that of financial misstatement. Did you misstate your financials at any point in time?
We did not misstate our financials at any point in time, but let me clarify that a bit further. The major driver of the allegation is the fact that sometime in 2013 or 2014, we disposed of a company called Oando Energy Exploration and Production Limited. At that point in time, the disposal was made. An agreement was reached between the parties, that's ourselves and the buyers, that a number of approvals were to be obtained subsequent to the transaction. So when, for example, the asset had an oil pipeline license, an oil mining lease, and because it had that, it meant that the approval of the DPR and the Minister of Petroleum was required. And the other approval that would have been required would have been the approval of the Securities and Exchanges Commission, because it was the disposal of a company in Nigeria. We agreed that those approvals were going to be conditions subsequent to the transaction and not precedent to the transaction. So the conclusion of the transaction was not predicated on those approvals.
Was that communicated to the SEC?
It was not communicated to the SEC because it wasn't required at that point in time. Because at that point in time, there were other approvals that we were seeking from the Minister of Petroleum, and which were not forthcoming, and which was quite public at that point in time. That's the disposal of the acquisition of the ConocoPhillips assets. One of the things that we did, not to muddy the waters, was to step down, at least temporarily, the approval from the Minister of Petroleum for that particular transaction, while what we thought was a much more important transaction was actually pushed through. Eventually, when we got that, the buyer decided that there was too much time lapse, and as a result, they weren't willing to go ahead with the transaction. What we had to do at that point in time was to then reverse the transaction to effectively nullify the transaction. We nullified the transaction, and one of the things that's required is for us to then look at any transaction that you nullify or you reverse and estimate what the impact would have been at that transaction that you nullified had it not gone through at that point in time, when initially you took it through. And we restated our financials just as a result of that. We restated the financials for 2013 and 2014 as a result of that. Now, the challenge that we then had was, as a result of the disposal of that asset in 2013, the company made a profit, and due to the demands of the shareholders, and we decided to declare a dividend. When we then reversed that particular transaction, the effect was that instead of a profit, the company would have made a loss.
But you've declared dividend?
But we had already declared dividend.
And you paid the dividend?
And we paid the dividend. And so that
And you can call the dividend back?
The dividend can't be
You can call it back.
back.
So you are therefore in a bit of a problem there. So how did it pace out?
Well, at any point in time, the actions of people can only be judged by the fact that at their disposal at the time those actions were taken. At the time the action was taken, we understood that we had a profit. We understood that there was a transaction that had already gone through, and we believed that the shareholders were due a dividend, and the dividend was paid.
I got a very key question. This time I got to be up. There's an issue of going concern. Is Oando Nigeria PLC a going concern or not?
Oando PLC, as of end of 2016, there were concerns about the going concern, and I would explain a bit. There were 2 or 3 things that really drove the issue of going concern. One was the fact that we had our net current assets were fairly significantly below our net current liabilities. The other one was the fact that we had reported losses for a number of years. Now, let me take the first one. One of the drivers for the net current assets, the third issue was the issue of leverage. The issue of leverage, I've already spoken about the fact that we've actually done quite a bit since 2015 to reduce the leverage of the company. And I must say that even in 2017, there are other steps that we've taken to further reduce the leverage. So that's the leverage on one side. The other one is the issue of the net current liabilities that the company had. That was basically partly driven by a technicality. A technicality in the sense that one of our facilities in the upstream had what you call a technical default. A technical default in the sense that some of the leverage, some of the target leverage covenants that we're supposed to meet were not met. It was a technicality. And generally, what happens when you've got things like that is that you then assume that if that deficiency is not corrected, there is the possibility that the lending banks could call on the facility. If they did call on the facility, then it meant that even what normally is not a current liability, effectively are allowed to treat as a current liability. I had a 5-year facility, and the portion of that facility that was due over 1 year, effectively I had to reclassify into this year.
We have to take a break.
Okay.
Thank you very much for coming on the program. We got more questions, but Ayotola Jagun, who is the Chief Compliance Officer and the Company Secretary of Oando Nigeria PLC, we answer some of those. That's Femi Adeyemo, the Chief Financial Officer of Oando Nigeria. Let's take a break. We're back in 2. We're back with the Oando explain some of the issues in the news. Let's keep the conversation going. You know where to find us on social media, at Channels TV or at Business Morning, or of course then you can tag me along at B. Bolson. Okay, let's get to the Chief Compliance Officer and the Company Secretary at Oando to talk to us, Ayotola Jagun. It's good to have you here, madam.
Thank you for
coming. It's your published or released documents on the Securities and Exchange Commission position was 9 pages. If I add the other 3 pages to it, that's about 12 pages. Looks like this is all you submitted to the courts a few days ago. Looks like this is already your position as far as these issues are concerned. So we will just take this as it is. But let's get started. Why do you think SEC was investigating your company?
SEC investigated our company because they received 2 petitions from 2 petitioners, and they are within their rights to do so. They receive the petitions, they look at the petitions, and they sent the petitions to the company sometime in May to say, we would like to know what your position is. Both petitions related to the 2016 financial statements of the company. We looked at it and we questioned actually the locus of one of the petitioners to actually bring the petition before the SEC, and also the locus of the SEC to actually entertain that petition. Nevertheless, we did go ahead to respond to every single matter that was in both petitions because we thought that the allegations were serious enough and required a response from the company, and also because the company had nothing to hide.
You are the chief compliance officer, so in terms of regulators, you are the one who has the handshake always with a regulator. So you are the person, not even the CEO. You are the first line of call if the regulator has any questions or queries and things like that. But now we get to this issue of forensic audit, the technical suspension. What's your position on this? I know it's already on paper, but what exactly do you have against an independent forensic audit, putting their boots on the ground in your offices, looking in your drawers, asking you to bring out files and books of accounts and perhaps other information?
We have absolutely nothing against it. The truth of the matter is we have supplied all that information to the SEC during the course of their information. So, of the investigation. Every time they would come to us with questions, we would cooperate and we would send them all the documents that they needed. Based on the information we've sent to them, they have reached certain findings. If they want to prove the veracity or otherwise of those findings, we believe that a very expensive forensic investigation is not the best way to go about that. The SEC has the right to have an inspector come into the company and actually look look at the books of the company. They have chosen not to go down that line. We believe that a forensic investigation, of which we don't actually quite understand what the scope is, how long it would take, we know what the cost is, it's not the best use of shareholder funds at this time. And, it's not also the best use of executive time. We have a business to run. This is a 48-year-old company. And, we have to continue this legacy for generations to come. It is not the best use of shareholder funds.
If someone else is going to underwrite the cost of this forensic audit, will you agree?
Again, we have to look at what the SEC wrote to us. The SEC said they want this forensic audit in order to determine the veracity or otherwise of their findings. So, to be honest, they've made findings. If they want a forensic investigation to prove that their findings are true, it means that their findings are, first of all, alleged findings. They are not sure whether those findings are accurate or not. They've had 5 months worth of information and investigation to determine that. If they feel that those findings are not true, then they should release their report and let's take it from there. We haven't actually seen a report. All that has been communicated to us is their findings. So we don't know to what extent submissions to them were actually considered, and we really don't know where they're coming from. So it's the open-ended nature of this forensic audit that is of concern, and we just feel that, again, it is not the best use of shareholder funds and not the best use of executive time.
Are there corporate governance issues in Oando?
There were 2 corporate governance issues that were highlighted from their findings. One was to do with the fact that we hadn't had a board evaluation since 2012. We had submitted to the SEC that we had had other forms of evaluations of the board, not necessarily in the nature of a formal board evaluation. We talked about our participation in the corporate governance rating system. We were one of the companies that successfully piloted that system. And we talked about the corporate governance review that we did at the request of the Nigerian Stock Exchange after we released the 2014 financials. Nevertheless, the penalty, if there is a penalty for that, is for the SEC to tell us to comply. And we are, at the moment, engaging a professional firm to do the board, to conduct the board evaluation. Now, as we've put down in our response, we brought that position to SEC's knowledge in 2013, in 2014, in 2015, and in 2016. When we file our annual returns, we tell them what we've complied with and what we've not complied with. So we didn't hide that fact from the SEC.
So that was on the table?
That was on the table.
So the SEC was aware of this?
They were fully aware.
And if there are penalties, you said in your position that you're willing to cooperate.
Absolutely.
Okay. Now, what about the shareholding structure, which is a very one of the very critical issues here?
Now, the truth is, if there is some inconsistency regarding the register of members, then it is up to the shareholder to approach the registrars to say the amount of shares that's recorded next to my name is not actually the number of shares I hold, and then to ask for a reconciliation. Our registrars have not received, and we as a company have not received any petition, any request from shareholders saying there's some inconsistency regarding what is in your register of members and what I actually hold.
In terms of disclosure?
In terms of disclosure, or even, in fact, the truth of the matter is the shares of the company are fully dematerialized. They are traded on the exchange. So if there is some discrepancy between what the shareholders have actually registered and what a shareholder believes he owns or he or she owns, then it's for them to do that reconciliation by providing the documentation from their brokers to say on so-and-so date, I bought this number of shares.
In 2015 was when Oando declared one of his heaviest losses, perhaps since incorporation. And the allegation was that some folks did insider trading or insider dealing. True or false?
I cannot speak to that as Oando PLC. The fact of the matter is insider trading is not something the company Oando PLC can be guilty of. We don't trade in our own stock. We have very clear insider dealing rules. We have a closed period policy such that, for instance, at this time, we're in a closed period and insiders cannot trade in the stock of the company.
And you are not aware
we are
that
not
anyone...
aware. We have no way of being aware. But SEC, if they are aware that people have traded when they shouldn't have traded, they have that, if they have that information, then it's for them to contact those individuals and to say to them, you traded when you shouldn't have traded and you breached the ISA.
But did the SEC send it as part of the findings to you?
They sent it as part of the findings to the company, and we told them the company is not in a position to respond to this. We have an insider dealing policy, which we communicate to all insiders. We have a closed period policy, and this is what we do as part of our closed period policy. And in fact, our policy is actually more stringent than the closed period rules of the Nigerian Stock Exchange. And we communicated those documents to them. So we are surprised that it is forming part of the findings against the company Oando PLC. It shouldn't.
A very straight question. What do you want from the Federal High Court? You've gone to court. So what do you want?
A return to the status quo. A return to the status quo in the sense that our shareholders, ultimately the company should be run in the best interest of the shareholders, of all the shareholders. And our shareholders need to be able to freely trade the shares of the company. Management needs to be able to continue to enhance value for its shareholders. And the current state of affairs does not permit us to do that. A suspension of the shares of the company sets a technical suspension, pegs the price at which the shares can be traded, and it's not a true reflection, or it doesn't give the company or the shareholders a true reflection of the value of the shares.
Do you see that no movement suspension as a protection, or you see it as a punishment?
To me, to the shareholder, it is a punishment. That is our belief, and that is why we are going. We went to court. The truth of the matter is the damage has already been done as far as reputation is concerned. And that damage had been done throughout the way this investigation has been conducted. What should have been confidential information between the company and its regulator has been leaked to the public and to the press throughout the course of this investigation, and it's done its damage. Yes, if the technical suspension is lifted, there might be another diminution, because there have been diminutions as a result of the leaks in the share price, but we believe it will find its level again. And, you know, we have, again, I must stress, this is a 48-year-old company. This company was formerly Unipetrol, and before that it was Esso West Africa. And it will continue. That is our prayer, that it will continue to be in existence and it will continue to drive value for shareholders for years and for generations to come.
I got about two questions for you, but the first one was that in July you issued a statement and you said the company is fully cooperating with the SEC.
Correct.
And towards the end of that paragraph, you said Oando will be happy to provide full disclosure of the outcome as soon as the SEC review is completed. Is this completed? Are you ready to provide full disclosure, or is this your full disclosure?
I mean, we believe that these are the findings. You know, we can only take our lead from what the SEC has told us. And they've said to us, these are our findings. We don't know if there are further findings, but this is what has been communicated to us. And we believe this information was communicated based on the full disclosure that we had given to date. Now, apart from the fact that we sent documentation, we also said to the SEC, I remember in our last letter, if there is any further information you want, please do not hesitate to get in touch with us. You would note that the company has been actually quite, some people would say reactive in terms of how it has gone to the public to say this is what is happening. And that was until this latest action by the SEC. And that was because we wanted to maintain the relationship with the regulator. We wanted to continue with full cooperation. And we have done so. Now, like I said, if there is any other information that the SEC feels it needs to be able to make its alleged findings final, we are happy to provide that information. But we do not believe that a forensic audit at the cost of 160 million naira is the most effective use of shareholder funds or the most efficient way to finalize its findings.
What is the future of Oando, the investors, and the debtors?
Well, like you know, Mr. Femi Adeyemo, who is our CFO, GCFO, said when at the interview he held earlier with you, you know, we are on course to turn the company around. We believe that turnaround has happened. We believe that we will continue to drive value for our shareholders if we are allowed to run the company as we should. Now, as far as our stakeholders are concerned, our business partners are concerned, our lenders are concerned, we are managing and we're successfully managing that relationship with them. And we continue to you know, assure them from our results and from our communication with them, our transparent, our continuous communication with them, that there is no cause for concern. At our last AGM, again, I want to point out that shareholders that were present, all shareholders that were present at that meeting, they approved all the matters that were before them, imposing confidence again in the management and board of the company.
We wish you all the best.
Thank you.
As they say in the legal world, see you in court next week, Thursday.
Thank you.
It's good to have you here. Do have a great weekend, madam, and the rest of your team. Thanks for talking to us here for the first time live on television, on Channels Television.
Thank you.
Ayotola Jagun, the Chief Compliance Officer and the Company Secretary at Oando, Nigeria. Let's go back after the break. You need to glow about something. What can you glow with? It's Friday. Something new is coming. As 2017 is coming to an end, we've got 60 days left, thereabout.